I mentioned when we started the show that we're going to have a very special guest, Mark Bendure of Bendure and Thomas. It's a law firm, and Mr. Bendure, Mark Bendure, is one of Michigan's preeminent appellate lawyers, and he is here to talk to us today a little bit about what it takes to make a claim for compensation when you've been involved in an automobile collision. As I said earlier, we were laboring under a case that found such injuries as fractured ankles and other terrible things like that to be not compensable under our no-fault law. And Mark Bendure single-handedly changed all of that. So welcome to the Law Show, Mark Bendure.
Thank you, Brian. Although I didn't do it single-handedly, there were a lot of people who filed amicus briefs and who complained about the unfair prior laws, and it all kind of came together. So it wasn't a one-handed operation by any stretch of the imagination.
Well, my listeners are very happy not only to know that you are an expert in your area, but that you're also humble. So tell us a little bit about the no-fault law, and if you can, in sort of some short statements, what was it that it used to be, what is it now, and what is the significance of the change?
Well, the statutory phrase was serious impairment of body function, and there had been a lot of disagreement about what that meant. And in 1995, the legislature enacted an amendment which said that it is an objectively manifested impairment of an important body function that affects the person's general ability to lead his or her normal life.
Oh, my God, how do you even get through that whole thing? That's too complicated.
Well, it is. But the former Republican majority had interpreted that even to create a higher threshold, and they said it had to affect the trajectory of your entire life, and that it had to be long-lasting, and a lot of other things which were just not in the language of the statute.
It sounds almost, Mark, as though they were saying, don't focus on the injury, pay no attention to the injury behind the green curtain. We want to see how it's affected your life. And if you've got a completely fractured ankle and you're limping for the rest of your life, but you can still go to work, is that something that somebody could win at court?
They could now. They couldn't before. I'll give you an example about Mr. McCormick's injury. He had his ankle fractured when a truck ran over it. He was unable to work for 19 months, had 2 surgeries, degenerative arthritis, and under this higher Kreiner standard, the Court of Appeals said, that's not serious impairment of a body function. There was a case, Mrs. Gagne, who had been creamed by a drunk driver. Her knee was screwed up. She was unable to restrictions on her movement for a year, a lot of indefinite restrictions, and they said there was no civil accountability for the drunk driver. So those were the sort of things that were happening before the McCormick decision.
So in that case with the drunk driver, our former Supreme Court majority, of which Robert Young is a member, supported that drunk driver in getting out of paying compensation to an injured party.
Yep.
Okay. So now what is the change? What do we show now?
Well, it doesn't have to be permanent. It has to be for a part-time. And the court, it's hard to explain, but basically the majority in the McCormick case went through each of those phrases and defined them. For example, when they said objectively manifested impairment, it wasn't that the injury had to be objectively manifested, it was the impairment. And then they defined objectively manifested as meaning that it was something that could be perceived by people other than the patient. And then they went on to say that it affects the general ability. It doesn't have to destroy the entirety of your life, but it has to affect its general ability. And they looked at the language to lead, and that is a phrase of passage. In leading your life, you pass through periods, so you focus on what happened during that period. And so basically they defined all of these terms in a fashion that was faithful to the language and had a middle line rather than the extremely high bar that had existed previously.
So let's bring this back to our listeners a little bit, and maybe you can give them some advice. Let's say somebody within the last 3 years has been involved in a car accident. Somebody's been involved in a Michigan automobile collision or a Michigan truck accident or a Michigan motorcycle accident, and they've seen a lawyer who has said, under the Michigan law, the Michigan no-fault law, you are not qualified to get compensated for this injury. So should they go back into that lawyer or a new lawyer and see if they're entitled to compensation now that the test has changed for whether or not somebody's entitled to compensation for a Michigan auto accident injury?
Absolutely.
Okay.
In the past, that was the advice that we lawyers had to give people, that under the way this earlier Supreme Court decision in Kreiner read, for all practical purposes, it was almost impossible to get compensation in a suit against the negligent driver. Since the standard has changed, there should be some people who would not have qualified before who would qualify now, and so definitely they ought to return and get an opinion based on the current state of the law.
Mark, I want to tell you, I really appreciate you taking your Sunday afternoon. I know you're a busy lawyer. You're very well-recognized and well-respected in Michigan legal circles. You took the time to come in and talk to our listeners about this. Will you come back and talk to us again?
Be glad to.
Excellent. Thanks again for calling in Mark Bendure, one of Michigan's preeminent appellate lawyers, who's just made it easier for people to obtain compensation after having been involved in automobile collisions.